and welcome to Legally Speaking with me, Tarun Nangia. We discuss a very important topic today. This is the economic impact of judicial decisions and court judgments in commercial debt related matters. Because obviously, courts on a day to day basis take a lot of decisions which have huge financial implications. And of course, if it has an impact on banking and lending in India, it is something that should be discussed. And the core principle we draw from what Justice A.K. Sikri spoke about in his judgment of Shiv Shakti Sugars versus Sri Renuka Sugar, where judicial interventions in commercial and financial disputes often operate as implicit economic policy decisions, with consequences extending far beyond the parties before the court. This is a very far reaching and profound comment that Justice Sikri made in his judgment of Shiv Shakti Sugars versus Sri Renuka Sugar Limited. But let me introduce you to my panel today who will discuss this topic. I want to welcome Justice Arjun Kumar Sikri. He is India's leading arbitrator by far. As we all know, he is also a sitting judge of the Singapore International Commercial Court, earlier served as the Chief Justice of Punjab Haryana High Court, the Delhi High Court, and also a judge of the Supreme Court of India. Good to see you, sir. Thank you so much for your time. I have with me Srinivasan Sridhar, who has served as the chairman of the Central Bank of India. He joins us on Legally Speaking for the first time, and looking forward to also welcome you many times in future. He's going to bring in the banking perspective. We thought we needed an industry expert because we are discussing banking today. I have with me Advocate Mahesh Agarwal, who practices extensively at the Supreme Court of India. His law firm is one of the leading law firms at the Supreme Court. Good to see you, Mr. Agarwal. And because the kind of matters that you deal with on a day-to-day basis, we feel that you will bring that gravitas to the discussion, where you will sort of bring in the issues that the economy could face because of judicial decisions on such issues. Because many times judges in retrospect say that, okay, this we didn't have an idea that this is going to have such a cascading impact. At the outset, let me request Justice Sikri to make an opening comment where I'll first lay down 3 points on which he can enumerate. The first one, because you made such a profound comment in your judgment of Shiv Shakti Sugar Mill, I want to ask you, should courts explicitly factor economic impact when granting relief in financial disputes raised by defaulting borrowers? And where is the line which stops between judicial adjudication and economic systemic function in India? If sort of you can also opine on this along with your opening comment.
Okay, thank you, Tarun, and thanks for inviting me on this discussion on this very vital topic, which I would say concerns directly with the economic growth of the nation. And when we are talking about 5 trillion economy, which as per the plans has should be achieved in within this year, India becoming third largest economy and going to overtake and assuming third place again during the course of this year. So, in that context, I would say we talk about this, of course, number one is that economic legislations and what kind of legislation they should be, and they should be the engines of economic growth. So, proper economic legislations become very important. Likewise, proper economic policies by the bureau, this executive. So first thing was legislation by the legislature, then by the executive also the policies should be aimed at achieving this growth, and so they should be growth oriented. And in this process, I would say that the role of judiciary also becomes important, which is the third wing of the state, because the whenever there is a dispute which relates to any, I mean, it may be on the face of it, like we have the ex-chairman of the bank, Mr. Sridhar. So it may be a case where suppose bank files a claim against a defaulter to whom few hundred crores or even few thousand crores were given and they defaulted. It may look to be a money case, but then And if there is a dispute, that has to be decided by the court. There is no doubt about it. But then, while deciding such cases, and because I have given a very, very simple example, but in real life, there would be example with complex issues and many nuances to this kind of simple recovery. It may be under SARFACI, it may be under before DRT, or it may be under IBC. So depending upon that, how the court have to be dealt with such issues, and many other legislations under Competition Act, under even the Income Tax Act. We have recent judgment in Tiger Global, I think. Yeah, that's the name of the judge. So, which is on which there is a lot of discussion about this. So, therefore, what I'm trying to say is that role of the judiciary also becomes equally important as that of legislature and the executive. So, while deciding such cases which have the economic impact, the court is not only discharging its judicial function, it has to also ensure that in the process, it is not becoming a roadblock to the economic growth of the nation. So therefore, and it's not that I'm saying it for the first. Yes, you have for the first time you have mentioned about my judgment in Shiv Shakti Sugar Mills, where I said so very eloquently. And but what I'm trying to say here is that look, ultimately the function of the courts is to do justice. There is no doubt about it. So doing justice in a given case, but then the important issue is what is justice. So justice may have different connotations, which may have different, I mean, outcomes may lead to different this, and that's why over a period of time, in few centuries, many jurists have come out with their on what we call legal theories or jurisprudential theories on what justice is. And importantly, say if I give you simple example, not becoming very, I mean, that way, like a class, jurisprudence class in a LLM or LLB, but I'm saying that there are some jurists who have said that look, the it should be maximization of wealth, which should be equal distribution of such wealth, and where we say talk about welfare economies, etc., and most fair resolution of a dispute, that is treated as justice. So therefore, once we talk about, and that is what the I mean, Kantian theory, as we call, Rawls theory also, as we call, they all mention about this. But then the another theory which has developed in last 40, 50, although it may be said in 200 years ago also, again I'm not going, but in last 30, 40 years it has assumed prominence, is economic theory of justice as well. So this is where judicial role comes in, and the economist or the jurist who propound this theory, because we have Judge Postner in America, who has also is a protagonist of this. He demitted office as a judge only a couple of years ago, and there are one another judge, yeah, Carl Bracey in America also, and they have been propounding these theories that economic justice we have to do, or we call it economic analysis of law, which means that yes, wherever economic principles are to be applied in order to achieve justice or in order to achieve very fair outcome of a dispute, those should be applied. And in that context, in Shiv Shakti Sugar Mills, I said that look, we should go into the economic aspect also. So in that context, yes, this becomes important, economic analysis. But then, of course, as I said, functions of the court is to do, I mean, to decide the dispute which has come before it. And while deciding the dispute, courts have also to then take into consideration, apply the law which is interpreted. If it is a case under IBC, they have to apply the provisions of IBC, in that is Insolvency and Bankruptcy Code. If it is under DRT, they have to apply those principles under that act. Or if it is under SARFACI, they have to see those. I'm just talking about these laws, but then there are many, many other laws also. And now economic principles are applied in many, many other cases. A contract, Section 73, when we talk of damages, economic principles are applied how to measure those damages. In torts, when we talk about again, which is a civil wrong, but then because of negligence of one person, other person has suffered some injury, etc., and we have to compute damages. Again, economic principles come. I give you the example of the even motor vehicles case, that accidents, etc. When we compute the compensation, again economic principles come. But leaving that aside for time being, what I'm trying to say is that, look, when it comes to these issues for which today's program is slated, that no doubt it has to be decided in accordance with law. So therefore that issue comes, which came before us in Shiv Shakti sugar mills also, and I have very categorically stated, first duty of the court is to apply law. There's no doubt about it. Not that we go into the economic impact, and economic impact is such that which is severe, therefore we ignore the law and do that. Then again we are falling into the trap, and the wrong trap. So therefore first duty is to apply law. But yes, and while applying this law, we know the courts have large discretion. Discretion is in interpreting that provision of law. While interpreting, we know we have the principles of golden rule of statutory interpretation. That is what the literal meaning of that particular provision is there. But we have the rule which is nowadays very I mean frequently applied, is the purposive interpretation. What was the purpose for which a particular law was enacted? And again, in the context of say IBC, that what is the purpose for which the law is enacted, that has to be seen. So in that context, the courts have discretion, and to just I mean take or I would say I should not use the expression digress from the provisions of law, but then try to find some solutions which are in conformity with law, but then coming out with some solutions which are in furtherance of economic principles. So therefore, when you say about this explicit factor, which is economic consideration, it can be taken into consideration wherever the legal rules permit, which are to be interpreted. And where the line is to be drawn, again I say that line which is to be drawn is if the particular and as you we progress, because these are my initial thoughts, as we progress in discussion, I'll give you some examples where I mean how the two factors can be balanced. On the one hand, the legal principles also, on the other hand, economic interest also, and where the court should not lean as a judicial function either totally in favor of one or totally in favor of other, and it is the balancing to be done in that process which has to be kept in mind. And my I mean one line answer would be, time has come, particularly by interpreting such laws or applying such laws, that economic principles or economic impact of the decisions must be kept in mind by the courts. You're muted.
Thank you for that opening comment. I'll go to Advocate Mahesh Agarwal for his opening comment on this issue.
See, I would say that economic legislation has been quite dynamic. Initially, we had, as you remember, Sikh Industrial Companies Act, then we had DRT, then IBC has come in. IBC, I think, is still work in progress. There have been multiple judgments of the Supreme Court interpreting provisions, filling in provisions which were non. As you know, the government itself has been like amending the IBC once a year, every year. So there are many issues which are coming up, and courts are intervening, and courts are giving judgments to interpret it in the interest of everybody. The borrowers, because the borrowers also have some interest, the bankers who have to recover money, and the successful the resolution applicants who are participating in the process, they also have rights. So the rights of each and every stakeholder is being determined by the courts. Every decision of the court has a huge financial impact for everybody concerned. For example, insofar as bank is concerned, they want the recovery to take place as early as possible. A resolution applicant who makes an application, he cannot wait endlessly. He has to block the money to acquire a company. If that process goes on for 2-3 years because of court interventions, court stays, the whole economic matter of the entire company will undergo a change. He may not be interested in taking over the company anymore. Similarly, there are workers involved who are who don't know whether to continue with the company or leave the company, whether it'll get resolved or not resolved, and the court step in there also. So every decision of the court has a huge impact on so many stakeholders, and which I think is necessary, because ultimately what is required for the courts to do is they have to look after public interest, they have to look after public revenues, because huge amount of bank money is involved which needs to be recovered. They have to look into industrial development. So many factors do come in into consideration by the courts, that any decision has an impact, and which the courts are looking into it. That's my opening remark.
Thank you for opening comment. Now we'll get the banker's perspective that the lawyers and the judges have spoken. So I want to know from you, uh, what is the statutory and the economic role of asset reconstruction companies? Can banks function efficiently without a viable ARC mechanism? And sometimes there is this whole theory of ARCs being misunderstood as greedy investors, rather than, they're doing a vital service to this whole economic system. And sometimes courts, when they are influenced by kindness, can compel ARCs to accept merely the acquisition cost of debt, which collapses the whole business model of the ARC. So for court, it may just be one case, and the whole ARC business model plus profit goes for a spin, uh, which sort of puts the whole sector into a quandary. And India gets a name as a bad market. That here, courts can get into your books and dictate what profits you will make. So, could you sort of give a sense of what it should be, and your opening comment? Over to you.
No, thank you. I'll make some general remarks before I get into the specific question on the ARC. I think the bankers need the courts very badly. I think the involvement with the judiciary and the legal profession has increased manifold over the last few decades. And this is because the the financing itself, of course, scope has expanded very significantly. The banks are doing types of financing which was not envisaged 3 or 4 decades back. Look at infrastructure financing, the way we are doing things now. And there are also very sophisticated techniques. The way we do receivable financing that we have done. I'm not talking about the automation part of it or the IT part of it. That's only a technique. But I'm talking about the general philosophy, the core philosophy of such financing. So in all this that we do, of course, we are beholden to our regulator, RBI, which is, of course, a very efficient and very forward-looking regulator in many respects. Although we may have our occasional disagreements with them as practitioners, but that's all par for the course. So, but having said that, I would say that the courts probably are the most influential factor for bankers now. Most influential. Regulator, yes, but the interpretation, even the regulator quotes the courts, not just in the recovery part of it. Recovery is one that gets a lot of headlines and attention, but even in the normal lending, in simple, transactions that we do on a day-to-day basis, and also in protecting consumers. See, that's also very important. And the courts have played a very important role there, because and as a practitioner, I can tell you, in the anxiety to do business, sometimes some of these aspects are lost, because in the field, you are a different person, because you are looking at budgets and things like that and how to do things. So I think the courts are very important. The other point which I think His Lordship had made was the increasing financialization of the economy. I mean, all aspects of the economy are getting monetized in some manner or the other. Financial is increasing, the degree of financial penetration in different parts, but we didn't think the growth of the entertainment industry is remarkably has happened. We didn't think even 10 years back it would go to this level. So what I'm saying is that, but the But I would say by and large, uh, the economic aspects become very important of judgments. And sometimes the we, of course, as bankers, look to the courts for guidance. The economic policies are also framed not specifically from a legal perspective. Of course, it's drafted legally and things like that. But the economic policies reflect the government, the philosophy of the government, the ideology of the government. But they may run into certain issues vis-a-vis the law, which of course our judges will interpret. Uh, the banks remain at the tail end. We sort of get whatever comes from the court, we try to interpret it through our regulator, and then try to internalize that in our various actions. So, this is the way today we are functioning. Uh, as I said, uh, particularly in cases of infrastructure finance, the allocation of spectrum, natural resources, coal, all these things have issues where the courts have played a very key role. And one of the expectations, there are a couple of expectations which the bankers have from the judiciary, because we feel that the judiciary is the last resort. So if there is any degree of fairness in the system, also in the economic system, it is the judiciary who will deliver it. So that's the sort of thing. Not because of any disrespect to other organs of our governance, but because of the way these organs are fashioned. That is one. The second is the degree of detail that the judiciary goes into in their judgments. I've had the privilege of reading some of these judgments and been involved in some of them from a, from a litigant point of view, and I've actually marveled at the precision and understanding, and also the ability to go much deeper than what the actual facts of the case, because the operational facts of the case present themselves. So it is actually a very important learning lesson for bankers, and we have tried to. I think most of us have tried to imbibe them, put them in our standard operating policies and procedures and things like that. So that's the other benefit of our interaction with the courts and with the lawyers also, because the lawyers are equally knowledgeable and are also quite critical in private, and therefore it is quite a useful exercise when talking to some of these senior lawyers. Now, coming back to specifically to your ARC question, I think in the at the time this ARCs were formed, it was a very timely initiative. Uh, uh, in fact, I had the privilege of being associated with the initial work which was done through the Asian Development Bank technical assistance on trying to understand how other countries did. And even today, I would say many countries don't have this ARC concept. And even many of the ARCs or whatever companies there, non-banking companies, do not are not regulated. They are unregulated entities. Whereas in India, all the ARCs are regulated. RBI has done it in a manner to bring some order and system into the whole thing. It is, if you are asking me as to whether it has been, it is now after about, I think there are 23 or 24 ARCs. Now, if maybe after some 20 years, is it something that we can live without, or can that be improved? It's difficult to say, but I think it's still work in progress. There are some examples where it has been, I think the ARC mechanism has been used for regulatory arbitrage, and therefore it may give rise to some criticism. But in my personal view, overall, the pluses outweigh the minuses. And having created this genre of institutions to do this, and having created a cadre of people who are well trained, uh, both and the combination of legal talent as well as banking talent, which is very necessary in the ARC. and ability to provide solutions and resolution. The purpose of ARC is not to close down the company, but actually to revive the company, and which is also, of course, the same purpose in our IBC, which also has a very unique feature of being a creditor-driven, not a debtor-driven law, unlike in many other countries. So overall, I would stop there to say that the ARC mechanism maybe there should be to look at what certain wrong practices that have crept in, that should be removed. But it would be impractical to expect the ARCs to do all these high-class professional services for free. The ARC has to survive. The ARC is also a financial institution regulated by RBI, and therefore the market they have to actually create that market. And there are several suggestions on that. Maybe we can discuss it as we go along in the discussion. So I would stop there.
Point very well taken. I'll go to Justice Sikri here and again ask the same questions to him on ARCs. That what happens to NPAs if in resolution, if courts influenced by the kindness quotient, they compel ARCs to only a cost plus mechanism, where the whole business model can then go for a toss. It may make for good newspaper headlines someday, but will it affect the sector? Second, you know, any business runs on risk. They may make a profit, they may make a loss. But if they are making a profit and the courts come and clamp down on it, will it affect the sector overall? You know, a sectoral pessimism may come in that India as a market is a place where if you make a loss, nobody bothers. You make a profit, there are, you know, many institutions where you can head and sort of using the courts also for this purpose. You can sort of make them look greedy and clamp down on the profits they can make. I want to know from Justice Sikri what he thinks about such situations.
Yeah, as Mr. Sridhar has rightly pointed out, you see, we have to see it from two angles. And number one, the whether ARCs are necessary, and they are, as rightly mentioned, for the last 2 decades. And in many companies, after taking over, and as the name itself suggests, asset reconstruction companies. So therefore, their main function is for the reconstruction of the companies, and the main objective is that, look, somehow that industry survives. Because if liquidation is to be done, winding up, etc., is to be done, naturally, then the liquidation will be, it's very easy for any court to say that, look, your assets are far below than your liabilities today. So company has become unviable. Let us close it. And pass a winding up order, appoint a liquidator who will do that. But where it ends to, it is only, suppose the assets are 50% of the liabilities. So what liquidator would do? Liquidate all those assets, 50%, so that 50% pro rata would be shared by the creditor. The ratio, which they have the priorities, because all creditors are not at par. That whether they are secured creditors, unsecured creditors, operational creditors, and all that, the workers who have their dues. So there are different kinds of, in government may have statutory dues, etc., income tax liability, custom liability, maybe, or excise liability. So those are all, are treated. But then the purpose is not that. That is only if the company cannot be salvaged at all, in spite of best efforts, and there is no other possibility which is left out. And that's why this our this Insolvency and Bankruptcy Code, IBC, again, Mr. Sridhar has already pointed out, it aims at first reviving, and we call it CIRP. That first, let us have the resolution plan, whether there can be resolution plan for reconstruction of the company. And in this whole process, that in order to save, because that is, again, we come to economic analysis, this solution should be the first attempt of the courts or the NCLT or NCLAT, etc., is for the reason that if the company survives, the company may be in production, the company may be in services, that is again good for the economy. Winding up is not good. retaining the company and make it profitable, which for whatever reason had become unprofitable. That is the main aim. So therefore, in for achieving this, ARCs have become important today in order to achieve this kind of. So therefore, if there are some ill effects or there are some malpractices which have come along the way, and the way some of the ARCs have functioned, the main solution should be to overcome those shortcomings, to find solutions for that. Not that the idea is not to kill them. So that is not the solution. Solution is to ensure that yes, these are the shortcomings or these are the malpractices which are being played by some of the ARCs. Yes, it has been happening. There is no doubt about it. Various kinds of, and Mr. Sridhar knows more, being a banker and directly in touch with these ARCs. We come in touch with these ARCs only from legal angle and when they are in the court. But what they actually do in day-to-day affairs, he knows better. So, and how to, therefore, but my only, suggestion is, and this is always discussed, it's not that we kill the institution itself, but try to reform it by bringing all kinds of reform which can be brought. And if this is the mindset of the judges also will deciding the cases, so therefore they should not, again, as Mr. Sridhar has rightly mentioned, that look, if ARCs are there, they are not here to do some charity. If they are turning around the companies, etc., and they are trying to, and they are helping in the whole process, then they have to get their remuneration also, because everybody comes for getting, even when we are doing, I am doing arbitration, I may be giving best services, but I expect my fee. A banker expects his salary while doing it. A lawyer like Mr. Mahesh Agarwal will expect his own fee also, and he will not be doing a case only on charity basis. Of course, in profession, if somebody comes and he's not able to pay, and it's a some worker comes and he wants, and he may do some case charitable on charitable basis as well. But that the main purpose is the earning. So ARCs, when they establish their such companies, they also have to earn. But yes, they should not be greedy in the process. They should not try to take a pound of flesh for the services. The remuneration should be reasonable and lucrative at the same time, so that they do their job honestly and faithfully. So therefore, these are the things, and that has to be kept in mind by the judicial authorities as well, or judges as well. Not that if somebody has earned profits or somebody has made money, as if this money is made only by wrongful means. That should not be the mindset. Yes, if something is found on facts in a particular case, that some misconduct committed or some malpractices committed, this ARC has done that, yes, come heavily. No doubt, because lesson is to be not only they have to learn the lesson, but message should also go across, that if we are able to find out any such ARC indulging in these kinds of practices, we are not going to spare them. So this carrot and stick policy, that should be adopted. That would be.
Thank you for so beautifully explaining this in the interest to safeguard that India remains an investment destination for even ARCs to work and flourish and contribute to the economic system. I'll go to Advocate Mahesh Agarwal for his comment on the same issue.
So I would say that when this whole concept of ARCs was conceptualized, it was a very bona fide idea that so far as banks are concerned, they should concentrate on lending, they should concentrate on industry building, and in case there is a bad debt or there is a bad promoter or they're not able to recover, give it to ARC, and ARCs are better equipped to either reconstruct or recover. So it was kind of an assignment of debt to ARC for this purpose. It was a very bona fide purpose. But why all these issues are happening is because the number of malpractices are now increasing. Some of the ARCs are now becoming fronts, either for the borrower itself or for a resolution applicant who has a target company to acquire. So if an ARC becomes a front of a borrower, what happens is a simple example that let us assume a company owes 10,000 crore to the bank and the borrower is unable to pay. The bank would assign the entire debt, say for 2,000 crore. Now, how can it be digested that an ARC who has acquired the debt for 2,000 crore turns around and makes 5,000 crore on that? No court would ever agree or condone this. So, when you say ARC should make profit, certainly they should make profit, but it should be a bona fide transaction. So, therefore, what the courts are doing now are scrutinizing whether the proper procedures are followed, proper rules are followed, if the transaction is completely bona fide or is somebody fronting it, because the court cannot digest loss to public revenue of 8,000 crore and a profit to a private ARC of 3,000 crore because of some jugglery. So therefore, court scrutiny is a must and it is happening. So the interests have to be balanced. The only now what Justice Sikri said, if there are malpractices, there should be plugging of holes. The regulatory mechanism has to become stronger so that these things do not happen. We are seeing cases where a resolution applicant ties up with an ARC, funds the ARC to acquire the debt, and then the company goes into IBC, and you acquire the company through the IBC absolutely clean. So the entire transaction is structured. It's not a genuine assignment from the bank to the ARC or a genuine IBC proceeding to reconstruct. The whole thing is pre-planned. Now, if those things come to light, now we have agencies like Enforcement Directorate questioning some of these transactions which have happened in the last 3-4 years. So when you're dealing with public monies of this scale and this nature, definitely ARCs are must. ARCs are carrying on business. They are giving a lending a hand to the banking industry, and they're a necessity. But when these kind of malpractices happen, the courts do step in. So courts are now stepping in to look into the transaction, looking into procedures to safeguard public interest, to safeguard public monies. So I think there is a balance which is required. We can't say that whatever
Yeah,
ARCs are doing is
Mahesh
fine.
is right there, and he has given very, very good examples. So, therefore, much minute and stronger scrutiny is required because such things are happening. There's no doubt about it. So, although we can't wish away from as far as ARCs are concerned, but at the same time, I mean, they have to be brought to discipline, and it can be with very, very stern measures in those cases where such examples which Mr. Mahesh has given, these are found to be correct.
And so one more thing, that when a bank has been dealing with a borrower for so many years and they assign the debt to ARC, at that stage itself, there has to be check and balance, a proper decision making process as to whether it is required to transfer the debt to ARC. The bank has to take a decision as to they are not in a position to recover. Ultimately, IBC is open to the banks also. The bank can also take the company to IBC and recover. So, what is compelling the banks to transfer the debt or assign the debt to ARC at a stage? That decision making process has to be absolutely transparent, has to be bona fide, reasons have to be recorded as to why the debt is getting transferred to ARC, and not as a part of a big strategy to kind of take money from the bank.
No, I agree with Mr. Agarwal Saab. Uh, but you know that there have been several such practices as the way that he was describing, and this is the common modus operandi. Very unfortunate. And actually, there is no other agency other than the court to come down on this.
Right.
Because what is happening is that under the which the IBC provides, under the guise of the freedom, commercial freedom that bankers have in fixing the various terms, that sometimes is used as an excuse. I'm myself a banker, and I have gone through many of these things myself. But I can say that in many cases that freedom is getting misused, and there is no other agency, because the Reserve Bank of India also, they do inspections and all that, but it's a risk-based inspection. They have also gone away from that. Some 15, 20 years back, they used to do what is called a more detailed inspection. This is more principles-based type of inspection. So the only agency today which can go into that detail, the government doesn't have the mechanism nor this thing. Of course, the investigative agency is based on certain complaints. may come into the picture, but that is always much later when everything has happened. So that I think correcting mechanism is a must. But I can say that most banks that I am aware of do have internal mechanisms to ensure that these decisions on transfer to ARC, actually transferring to ARC is a quite a big decision for banks, and then particularly the pricing aspect, and whether it has to be cash, whether it has to be SRs, what they call it, security receipts. Because I remember when the initial concept of SRs were introduced, one of my German friends, banker friends, told me it seems to be a Ponzi scheme. You are only, you are just transferring the NPA and then taking back and you yourself are investing. क्या होता है? What is this? I don't understand क्या चल रहा है. Is it officially sanctioned whitewashing of your loans? Yeah. We were raising some money in the German market, and therefore he was going through our balance sheet and things like that. So we had to explain to him and all that. So there is an issue of international credibility as well, as Tarun has been pointing out every now and then. It's very important, and the success of IBC is extremely important in my view for that. And a very well conceived measure. It should not get lost in many of the technicalities that has happened and the interpretations and all that. So coming back to the ARC point, I get the sense that our esteemed panelists would like the ARC mechanism to continue, but with corrections. And which, as I said in my own remarks, that it is absolutely necessary. It's very useful for the bankers, extremely useful, particularly in the cases where they are not controversial. Some of these borrowers are controversial guys. They have tremendous clout, and they do so many things. If you remove that sort of upper layer, a creamy layer, then it is easily workable, in my view. I have seen it. And also, you see, particularly in the public sector banks, the government must support. Enable the banking people. Because I have worked all my life in public sector, so I'm speaking from that perspective. That support from the government is very important, so that that don't worry, as long as you have been doing things clearly, cleanly, there's nothing to worry. You have to do. So that is important. And the bankers, honest bankers in India, I'm not saying this because his lordship is here, but the honest bankers in India look to courts as the final, arbiter of that destiny. Because, internal mechanisms and supervisory mechanisms can sometimes fail them. But the courts generally don't fail. They've always supported. And because, because first of all, I think because the courts themselves enjoy immunity, if I may say so. And therefore, they are able to speak with that independence and with that, authority, which is so comforting for bankers. I can tell you that. I can tell you that from my personal experience. Very, very, very thing. So courts are in a exalted position. We have to keep them there, and we have to the society, the governance mechanism, maybe the parliament or whatever it is, have to ensure that the courts remain above this dust and din that is there in us in this. But be in touch with all the relevant developments, economic developments that are happening. In some countries in Europe, there are special economic courts, and there are, constitutional courts are different, criminal courts are different. But I think in our country, we have the same courts. Of course, the NCLT and the tribunals have created an alternative adjudication mechanism. But by and large, I think our model has served well. But I would want to hear, if I may say so, from his lordship on his views on how does it make sense, because increasing commercial nature of our society.
Mr.
I
Sridhar,
suggest I have only one thing, that I'm sure that bank has a proper decision-making process at the time of assignment. See, we are doing litigation at a much later stage, and the questions that arise then can be addressed at that stage. For instance, at the stage when the matter goes to dispute, then we are able to point out after some investigation or diligence that the funding of the ARC was either by the borrower or a prospective SRA. Correct? So when the bank is assigning a big debt to an ARC, there should be a mechanism of checking the source of the funding of
Correct.
ARC
Absolutely right.
as to where the
Absolutely
money is coming from. If it is coming from the borrower, then I mean it's a scam.
correct. Absolutely.
Secondly, we have also come across cases where the transactions are actually bona fide. The banks have entered into a transaction of assignment to ARC on terms which suggest that over and above the interest which ARC will get, whatever extra profit is done on resale, there is a apportionment between the bank and the ARC. So, for instance, that you, like I gave an example, the 10,000 crore debt is assigned to ARC for 2,000 and it is sold ultimately at 5,000. After adjusting for the interest, the delta of 2,000 is shared between the bank and the ARC. So that way, at least the bank gets benefit of the recovery which is done later on. And ARC also gets the fruit of its effort by not just interest, but a part of profit also.
Point
That
very.
is a.
I'll add to add. You want to come in, Mr. Sridhar?
I'll just add the one point and then I'll keep quiet. So one is this, that point that Agrawal Saab made is absolutely valid because that's now accepted across financial services industry. In private equity, for instance, when there are exits, there is a concept of carried interest, as you're all aware, and there's an 80-20 share. In mutual funds, I mean, there are so that concept also, there is nothing wrong with that. I think, and that should be encouraged actually, because that will incentivize bankers to go more for ASS. Bankers are scared to actually to sell loans to ARCs because they don't know what it is, and the proper evaluation of the ARC has suggested if the net worth of the ARC itself is only about 100, 150, the minimum 150 crores, how can you sell a portfolio of 500 crores and things like that? What is the use of their SRs? If they issue. So there are all these questions in which common sense and normal banking prudence has to be employed at every stage. We cannot escape from using banker cannot escape from using his prudence, and whenever in doubt, err on the side of caution. This is what is expected of a banker. And please go ahead.
On part one, I'll like to take the last question for today. We'll have much more to discuss in part two. That when Justice Sikri referred to Justice Posner and also a Shiv Shakti judgment, so do you feel that court judgments should not end up indulging the defaulter and then sort of having an impact on the ARC and the banking lending system, whereby the defaulter uses it to end up paying much less than even the borrowed amount after the debt is assigned to an ARC? And this whole constant, sense endeavor to do justice may end up indulging the defaulter more than anything else. Would you want to reflect on that?
I think, Tarun, this is a very, very valid question. And if I may say so, while deciding particular cases, it may be a dilemma in the mind of judges also. So it is, as I said in my opening remarks, about balancing. You see, that is the judicial mindset normally, and that is how lawyers, I mean, rather from our college days, we are trained when we are told about rule of law, that, and we are told about justice, and justice in the context of, so like we have inherited English system of law which is there now and it is based on common law. So common law talks much of equity. So therefore, and in our, that is one part, our constitution also talks about social justice. So it's not, I'm talking about social justice also, and justice for poor and etc. and all these things. So in view of this, many times there is a conflict on the, so and the judges approach in decision making. So it would be how it should be guided, whether on the one hand they are legal precedents, so there are judgment which are shown that look, in such and such case equally like this Supreme Court had done, was High Court, that may have happened 20 years ago, 30 years ago, but maybe a valid precedent even now. But then there are the principles of fairness, efficiency, and as I said, broader societal values which go into the decision making, and particularly by Indian judge who is, I mean, to go into, not only, I mean, have to see the conditions in the society and how Indian people are there and the common people are there. But because, of course, we are here talking about big companies who have taken big loans from the bank, etc., and now their cases for recovery, they come, and then all the IBC proceedings, etc., are filed. But still, at the back of the mind, the judge will have efficiency versus equity, always some kind of struggle. And a person may be, say, I mean, a big businessman or something, but there may be some, as we call in our legal language, mitigating factors in his favor. And you see, Shakespeare has said one thing which I always use here. And Shakespeare said that there are some people who are born genius, so from the birth, they are genius and they will prove to be genius. There are some persons who acquire genius. So maybe normal, but during their life, the way they, I mean, proceed with the, or they work towards that, they work hard, etc., whether it is education or other things, so they become genius. But then there is a third category, that some persons on whom genius, I mean, that it is thirsted upon them. So it is perceived, and they are that, oh, these people are genius. So likewise, when it comes to why businesses fail, so there are some businesses which are bound to fail from very beginning. The very idea was wrong. Mr. I think Sridhar would know that many times the people come and all that such a business, it should not have been conceptualized in the first instance because of going by the economic consideration and ecosystem, etc. So these are those, and therefore they, in our earlier we had that Sikh Industrial Act. So in that context, I use so they are born sick. These are the industries which are born sick. Then we have the those which acquire sickness, or they become bad, or because of circumstances. Here it is. I give you again a simple example that say steel industry couple of years ago, I mean 10 years ago or so, there was no fault of theirs. But China, with so much of steel production, and started, I mean, this dumping their goods in India. So here the price of raw material was more than in India, was more than the price at which the steel is sold. So who will start? It, so therefore, now because of these reasons, you acquire sickness because your goods are not sold. And the third is sickness is thirsted upon that is those where it is mismanagement of the promoters. They have, and there are examples galore. Beginning, they may have done very good, but then over a period of time, becoming greedy and diverting this income into some other personal, I mean, for their personal benefits, or frittering away with the assets. We have some fugitives who have run away from India, and they are in other safe havens, and we know how they did. So therefore, you have to come very now in a case which comes, then coming back to your question. So therefore, the courts are to see this particular industry falls in which category, whether it is the first category, whether it is second category, or the third category. So when it comes to first one and second category, then yeah, they'll say that look, company was managing well, but because of other economic considerations, this is the problem, and it may come out of that. First category, sorry, because the concept was wrong. It was never meant to do this business, so wind down that company. Second category, revive that company. Third category, come heavily against those promoters and punish them in whatever way you can, because it is the company has gone into losses, etc., because of the mismanagement, because of misdeeds, etc. So therefore, but that has to be kept in mind. But there would always be a struggle, as I've said that. But then the fairness, equity, etc., should not even be applied in the case of category number 3. It should be only in the case of category number 2. Category 1, yeah, sorry, you go ahead, you go out of the market. We don't need you, because even if you are here, you are going to suffer losses also in future as well. So this is what, in nutshell, would be my
In
answer.
fact, in a lighter vein, I would also like to add, once an eminent jurist told me that there are two kinds of judges. Judge number one, in his pursuit of justice, will end up destroying not only an industry but the entire sector. But then we'll say that I did justice, leading to loss of lakhs of jobs. Even bilateral relations between countries will get destroyed. But he can come out of retirement and say, I did justice. There's be judge number two, who will sort of follow the principle of justice Postner and ensure commercial wisdom also is taken care of when judgments are pronounced. And this was, of course, during an arbitration conference that this was discussed. So this was, I think, a few years ago after the 2G and the coal judgments, and they, in
Yeah,
retrospect,
we can discuss 2G and coal, and there can be a very, very lively jurisprudential discussion. The economic impact was, again, in both the cases, what the result was it had a devastating economic impact. But yes, if you see the principles applied of administrative law, constitutional law, of fairness, etc., the action of the executive was found to be, lacking in that, and therefore it was. Now, the dilemma again, if I answer this question in the context of 2G and coal, so suppose in that case, yes, one outcome could be that you punish these who have got the license, don't revoke their license, don't, now they have invested lakhs of crores, employment is also there, and starting
yes,
everything from beginning. And as we know, in the case of 2G, many foreign players, they had gone back after that,
yes,
and
yes,
so much of foreign investment was lost. So therefore one thing was said that, look, don't do this. Although it is only after, before the court, it was not even argued. Economic analysis was not even undertaken. But suppose all this economic effect, which was seen later, had been discussed before the court, and court had leaned in favor of that, and by imposing some fines, etc., and saved it. Then the another problem which comes is, then the other criticism could have been that, look, then where is the good governance? That means anybody who can pay, give money and get away with this. So therefore, you get the license illegally. You have influence in the government. You are able to get that, and now you are, the court is also not, court is also saving you only because you have money and you are paying some fines. So these are, that's why I started with this. I had this in mind, that this dilemma would always remain in the mind of judge while deciding such cases. So, but then yes, there are ways to find out. Suppose in these two cases only, had these disastrous economic consequences brought before the court, and had court noted all this, then court has power under section 1, article 142 also,
yes,
denounce, and the courts have gone with the principle of prospective overruling as well in Golaknath case, although it was overruling of the in the in the field of legislation, but then that has been applied now, even in the executive field also later in some case. So court could have said, yes, we are not going to tolerate this, but under these circumstances, we don't want this kind of situation where, giving all that statistics, that this is going to lead to all these economic consequences, and it will put back the economic growth of the country by several years. So therefore, we, after holding that this is all wrong, we are coming out with this, and then doctrine of proportionality can also be applied. So, had if the judgment is given more craftily by employing
yes.
these kinds of armory, then their criticism may not be there also.
Point very well taken. I very well know, Justice Sikri, where you stand on this, because we've discussed this many times, and appreciate you sort of joining us. In part two, we'll get to into this in much detail, because many times in retrospect comments can be made, but it is a person who decides at that time. All pressures and everything comes to him. But I would like to thank Justice Arjun Kumar Sikri, Advocate Mahesh Agarwal, Srinivasan Sridhar, who is former chairman Central Bank of India, brought in the banking perspective, joining us on part one. Part two, we'll delve into greater detail on these aspects because I think I could see a lot of Advocate Mahesh Agarwal looking to speak a lot more. Even Mr. Sridhar, I could see nodding when Justice Sikri was speaking. So we will get in that on part two. Appreciate your joining us on this very serious, important issue, which has implications for the banking sector of India, the ARC of India, which will grow in future, I'm sure. Thank you so much.
Thank you.
Thank
Thank
you.
you. Thank you.